today's very special meeting. I will read the agenda. It is on the screen. It's the opening and welcome by the chairperson, apologies, and then we will go to the negotiating mandates under Children's Amendment Bill Section 76, B18B 2020, and then responses on the mandates, submissions by the Department of Social Development will follow, and then deliberations and any other business. Before I give my opening remarks, I would just like to know, because we're expecting members from the legislatures, I would love members to switch on their videos. Let's start first by all our members by introducing yourselves. Please switch on your video before we can continue with the meeting. And I just have a move and a second for the adoption of the agenda first, please. Yes, Member Nkosi.
What are you saying? The adoption of the agenda.
Thank you.
I'm moving for the adoption, Chair. Thank you.
Thank you. Is there a seconder? I don't see any hands. Is there a seconder for the adoption of the agenda?
Chairperson, it's Delmain Christians. I second.
Thank you, Member Christians. Then members, let's move then. Let me introduce myself. I am Member Gillian. I'm the chairperson of the Select Committee on Health and Social Services, and then I will ask all our members to do an introduction and then just switch on your video when you do your introduction. Thank you.
Chairperson, it's Delmain Christians. I am a member of the Select Committee on Health and Social Development. I serve on the committee as well with you. And I'm here on behalf of the Northern Cape, DA in the Northern Cape. Thank you, Chairperson.
Thank you, Member Christians. Is there any other one?
Yeah, thank you very much, Chair. It's Member Nkosi. I'm the member of this Select Committee, serving in this committee representing Mpumalanga Province. Thank you, Chair.
Thank you, Member Nkosi. Member Chabaleng, I see you here.
Yes, my video is on, even though I don't see. My name is Elegant Chabaleng. I am a member of this committee. I originate from the province of Limpopo. Thank you very much.
Thank you, Member Chabaleng. Is there any other members from the Select Committee that has signed in already?
Hello, Chairperson.
Hello.
Yeah, my name is Noikili from Northwest. I'm a member of the Select Committee. Thank you.
Thank you, Member Lei.
Chairperson.
Yes.
My name is Linda Lutuli from KZN, member of this Select Committee.
Thank you, Member Lutuli. Is there any other member on the platform? Not yet. Marcel, do we have members of the different legislatures that have signed in?
Good afternoon again, Chairperson. I did see a member from the legislature. I saw Honorable Swartboy Ntombela from KZN, Chair.
Okay, Member Tumbela, can you switch on your video and introduce yourself?
Thank you, Chairperson. My name is Gloria Nonzwagazi Ntombela, the Chairperson of Social Development Portfolio Committee in KZN.
Thank you very much, Chairperson. If we don't have any others, can I then ask Department of DSD if you can introduce your members who is on the platform?
Sorry, Chairperson.
Yes.
Honorable Member Filwe Kekana from Gauteng, Chairperson of the Portfolio Committee Social Development. Thank you.
Thank you, Chair. Department of Social Development, can you introduce your members? It seems like we've got a problem with the DSD. Can I then ask Marcel? We've got in this meeting the legal departments. Can those two members just introduce themselves?
Good evening, honorable members. Luyanda Mchochisa from Legal Services, the Department of Social Development. Thank you.
No,
good afternoon, good evening, honorable members and chair. My name is Gosnat Lata from Legal Services, National Department of Social Development. Thank you.
Thank you. Nati.
Good morning, good afternoon, Honorable Chairperson and honorable members and my colleagues. My name is Nati Mjengane and I'm from Parliamentary Legal Services. Thank you, Honorable Chair.
Thank you. Before I move into the support staff, Member Chubi and Member Baha, can you introduce yourselves into this meeting? Please switch on your videos and welcome in the meeting. And Member Ndongeni.
Good afternoon, Chair. I'm struggling with my video setup.
No, it's fine.
But I'm Bulelo Baha, a member of this committee. Thank you, Chairperson.
Thank you, Member Baha. Member Chubi.
Good afternoon, Chairperson and members. My apologies, Chair, for the inconsistency of the camera. I'm on the oversight of, concluded the oversight of other committee chairperson. But my name is Itmele Nzugu. I'm the member of this committee. Thank you very much.
Thank you, Member Nzugu. Member Dongeni, are you in?
Yes, Chair, I'm in. My name is Noguzola Ndongeni. I'm a member of the committee.
Thank you, members. Marcel and the team, can you guys introduce yourselves so that people can also see us doing this hard work behind the scenes?
Good afternoon, Chairperson. I'm having some issues, Chair. Afternoon, everyone. My name is Marcel Williams, and I'm the committee secretary for the Select Committee on Health and Social Services. Thank you, Chair.
Thank you.
Good afternoon, honorable members. My name is Mkululi Molo. I'm a researcher for this committee. Thank you.
Thank you, my dear. Tabile, where are you?
Good afternoon, Chairperson, members and colleagues. I'm Tabile Keke, the content advisor for the committee. Thank you.
Thank you. We've got a new person who has joined us as the committee assistant, Mr. Kolisile Lobby. Can you switch on your mic, please, and your video?
Excuse me, Chairperson Marcel again. I don't think Mr. Lobby has joined, Chair. I think he's busy with committee work. Thank you, Chair.
Okay, thank you, Marcel. So without any further ado, members, we have received 2 apologies. The one apology is from the Deputy Minister that is still booked off sick. The second apology is from Minister Zulu, who is attending the GBVF summit together with the president. And I would like this meeting to accept the apologies or decline the apologies. It's open for members. Can we accept the apologies, members? Member Chabaleng, I see your hand.
Yes, Chairperson, we accept the apology.
Thank you, Member Chabaleng. Member Kosi, do you second?
Yes, Honorable Chair, I'm seconding.
Thank you very much then. With all technical issues out of the way, let's continue with this very important issue. Members, can I ask that you please switch off your microphones if you don't speak? Mapulas, who's Mapula? Can you please mute yourself? Thank you. Members, let me give an overview of where we are today and where we're coming from. We received a briefing by the Social Department of Social Development on the 13th of September 2022, which was then followed by briefings on the bill by the committee members in the legislatures of all 9 provinces. Public hearings were then held in all provinces. Advertisements were placed in local and regional newspapers, as well as Parliament social media platforms. The Select Committee on Health and Social Services, advert was 23 September to 21st of October 2022. So today, members, we are here to get the negotiating mandates from all 9 provinces. What I will do, I will ask each member who's representing the province to read aloud the negotiating mandate in alphabetical order, and I will start with the Eastern Cape.
Chair, just
Yes.
a minute.
Yes, Member Dongeni.
Just a minute, Chair. Okay. The province vote in favor of the bill with proposed amendments, and therefore mandate the permanent delegate to the NCOP to negotiate in favor of the bill within the following parameters. Thank you, Chair.
Thank you, Member Dongeni from Eastern Cape. We will then move to Free State.
Thank you very much, Chairperson. The province of Free State has mandated as Chairperson to vote in favor of the bill. Thank you very much, Chairperson, as I submit.
Thank you, Member Chubi. Gauteng. I know we've got the chairperson of Gauteng Social Committee in the meeting. And Member Baga is also here.
Chairperson, I'm trying to get to it now. Yes. Chairperson, the Gauteng Provincial Legislature votes in favor of the bill with proposed amendments and mandates the permanent delegate to the NCOP to negotiate in favor of the bill. Thank you, Chair.
Thank you, Member Baga. From Gauteng, we move to KZN.
Thank you, Chairperson. This is KZN.
Thank you,
The Portfolio Committee on Social Development met on Friday, the 28th of October 2022, and agreed to mandate the KwaZulu-Natal delegation to support the Children's Amendment Bill B18B 2020 with the following amendments attached hereto into the committee report. I thank you, Chairperson.
Thank you, Chairperson. From KZN, we move to Limpopo.
Yeah, thanks, Chairperson. The provincial NCOP permanent delegate to negotiate in favor of the bill, subject to the proposed amendments as contained in the attached portfolio committee report. Thank you, Chairperson.
Thank you, Member Chabaleng. From Limpopo, we move to Mpumalanga.
The linear registration number.
Thank you very much, Honorable Chair. The Portfolio Committee on Health and Social Development, after considering the Children's Amendment Bill, confers on the permanent delegate representing Mpumalanga Province in the NCOP a mandate to vote in favor of the bill. I thank you, Honorable Chair.
Thank you, Member Nkosi. We move to the Northern Cape.
Thank you very much, Chairperson. The Portfolio Committee in the Northern Cape deliberated on the 28th of October 2022 and has mandated us to vote in favor of the Children's Amendment Bill. Thank you, Chairperson.
Thank you very much. We will then move to Northwest. Member Lehi, are you here? Did we lost Member Lehi? Okay, let me continue with the Western Cape. Can somebody try to get out of Member Lehi? Is he still in the platform? Member Latuli, can you read the negotiating mandate on behalf of Member Lehi, who's not on the platform for the Northwest? Are you also not here? Okay, Member Chabaleng, or let me ask Member Nkosi. Member Nkosi, can you just read the Northwest Legislature negotiating mandate, please?
It's me here. Oh. Yes, sir. Thank you very much. Thank you very much, Honorable Chair. I'm struggling here. I don't have stats with me. The Northwest Provincial Legislature votes in favor of the Children's Bill Amendment Bill. Thank you very much, Chair.
Thank you, Member Nkosi. Okay, I will read mine now for the Western Cape. I must just get there. Okay, the Standing Committee on Social Development, having considered the subject of the Children's Amendment Bill B-188/2020, referred to the committee in accordance with the Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to support the amendment bill with the attached amendment. The Western Cape therefore supports the bill. I thank you. Members, sorry, I just muted myself. We've got all the mandates from the legislatures, which means all 9 provinces have voted in support of this bill. And I just need to thank all our members and members of the legislature who was part of this process. I will now ask the Department of DSD and also the legal departments for their inputs. Who is going to talk on behalf of the Department of Social Development?
Good afternoon once again, Honorable Chair and Honorable Members. Luyanda Mchochisa will be responding to the comments that have been made in the provinces, but I'm not sure if there is someone from the department who is going to do an official introduction before I take you through the presentation. Thank you, Chair.
Okay, now I think you can continue because both the minister and the deputy minister is not in the meeting. You can continue.
Thank you, Honorable Chair and Honorable Members once again. Just to indicate that we highly appreciate the comments that have been made in all the provinces and the negotiating mandates that have been received. As a department, we received the comments as has been made by the relevant provincial legislatures. And now the purpose for this presentation is to highlight the issues where we are in agreement therewith and issues where we disagree, and then sponsor our response with regard to our disagreements. But that is not very much so with regard to the nature of the comments that we received, Honorable Chair and Honorable Members. Most of the comments that were received were actually in support of this bill, as the mandates have indicated. And also the other issue is that some of the comments that were received were not necessarily in line with the bill that was presented before yourselves. Again, Honorable Chair, there are areas where we have not supported the comments simply because, as I indicated, the comments fall outside the scope of this bill, and where we support the comments because they are in line with the bill, and where we also support the comments in terms of a suggestion to modify the current clauses of the bill. So with your guidance, Honorable Chair and honorable members, I'm not sure whether we should read everything word for word where we were not, where we are in support of that particular comment, or we just have to go for the highlights in terms of that particular provision. We stand to be guided by you. Otherwise, we have the metrics as in the screen, which is about 213 pages, which we can go through word for word, if you so agree, Honorable Chair and honorable members.
No, you can just read the highlights.
Okay, thank you, Honorable Chair. The first comment that was received was around genital mutilation, and the comment was indicating that the bill must provide for the prohibition of genital mutilation. We do not support this comment, Honorable Chair and honorable members, because it falls outside the scope of the bill as presented. Again, around that particular topic, there is an issue around intersex genital mutilization, and that comment is also not supported because it is not part of the bill that was presented. So basically, all the issues around genital mutilation, which were presented by the groups relating to the rights of women and children, that was rejected, Honorable Chair, as it fell outside the bill. But we must indicate, Honorable Chair and honorable members, that the rationale for not supporting this is not that we are rejecting the issue as less important, but we are rejecting it on the basis that there is another bill, that is another version of the Children's Amendment Bill that is in the pipeline, which will be a committee bill very soon. And these issues will be dealt with in terms of that particular bill. So all these pages, as I'm going through them, they are more on genital mutilation. This is also a topic that was also featuring more in the bill. That is the one that had 146 pages or clauses at the time. The other issue was around with the issue of the commissioner for marriages with regards to the underage marriages, Uguthwala in particular, and that issue is not supported, Honorable Chair and honorable members, because it also falls outside the scope of this bill. In Section 22 of the Act, the other issue that was commented on was around the issue of discipline, that is disciplining of children, and we do not support this particular view, Honorable Chair and honorable members, because it falls outside the scope of this bill. Same as the comment around Section 91 of the Act, which talks to the programs that relates to the parents and guardians dealing with how children should be dealt with, and more especially children with disabilities, and that issue is also not supported as it falls outside the scope of the bill. Again, with regard to Section 111 of the Act, that is the Principal Act, the issue of the database that must be linked, that is the register for offenders that must be linked to the South African Police Services or the Department of Correctional Services. That issue is also rejected by the department as it does not form part of this bill. Again, with regard to Section 250, which is clause 123, in terms of the other bill, the issue around the lack of resources around, say, in being enough personnel in terms of officials. That was also not part of the bill. Therefore, it was not supported by the department. Again, the issue of the process in registering a drop-in center, which was also not supported as it fell outside the scope of this bill. Again, the issue of the comprehensive legal solution by the National Treasury. The main aim of the bill to address the current gaps and challenges in the child protection system and to deal with High Court order related challenges with the provision and administration of foster care. That is the comment that was made. And over and above, the indication was that one of the main challenges relating to the automatic lapsing of foster care orders, which placed an unnecessary burden on the system, was because of these challenges that have been indicated. So the issue was more about the extension of the order as an alternative care. So the issue was whether this particular bill does provide for a comprehensive legal solution in terms of that. And our response is that yes, it does, because the amendment of section 159 forms part of the comprehensive legal solution to address foster care challenges. That is why we are talking about 6 months extension that must be taken into account in order to prevent these orders for lapsing. So we have noted the comment, but there is nothing that we need to do in terms of the bill itself, because it has already been provided for. Again, the issue of adding a provision that not more than 6 children may be placed in foster care with a single parent. Yes, this was one of the contentious issues in terms of how many children can be placed under a cluster foster care scheme and all that. And we are saying, yes, we are mindful of that. The limit is 6, but we must take into account that in an event where these children belong to one family, they are siblings in a way. Section 185 of the Children's Act already provides for that in under such circumstances, those children may not be separated, but taking into account many other issues. So the issue of enhancing supervision as added provision that even after being in foster care with the same family, same person for 2 years, that the court may still order that social work reports must at all times be submitted. So there is a need then to rephrase section 186 subsection 4 in particular to be substituted and replaced with the following wording. That is subsection 1 and 2 do not apply to orders for children placed in foster care. So we'll be taking into account of that, Honorable Chair and Honorable Members. And again, with the issue that this particular section does not apply to a cluster foster care scheme. So that is what we are going to be responding to in the version that we'll be working on. The issue again that foster care with a family member, this is what we have been talking about around the issue of children who are not necessarily, who are orphans, but not necessarily in need of care and protection, will be placed with the family. And yes, these children will be benefiting from the child support grant top up as has been introduced in terms of the Social Assistance Amendment Act. The other comment that we received was about the new version that must add a provision that an order placing an orphaned or abandoned child in foster care with a family member before on or after the date of the amendment of this act may be extended. So it was not clear as to what exactly is being asked by the person who made a comment, and we could not necessarily make sense out of it in order to amend or to support as well. Again, with regard to the issue of cluster foster care schemes, whether they can be operated by a designated child protection organization, and we did look at the act and indicate that yes, also the bill does make provision for NPOs to be designated as a child protection organization. So we confirm what is being asked, that indeed there's nothing that we can do because the bill already provides for that. And also the issue of adding a provision that if a children's court finds that a child is in need of care and protection, that the court may make an order that the child be placed in the care of a parent or family member if the court finds that such a person is suitable to take care of that particular child. And we are saying the bill does make provision for such a placement to be recognized in a cluster foster care scheme. So it's one of the comments that we say, yes, it does support in a way that which we already have in the bill. And there is also a need in terms of the other comments to add a provision similar to existing provisions relating to the Minister of Social Development and the National DSD, that the MEC in a province may, subject to any provincial strategic plan, enter into an agreement with a designated child protection organization or other appropriate person. And we say, yes, the agency agreements in their nature, they do provide for that, and the service level agreements that are often entered to in order to deal with the issue of quality assurance for the child protection services that are being offered, and the child protection organizations themselves, which has been added in terms of this particular bill. The other issue, Honorable Chair and honorable members, was around the expansion of the jurisdiction of the Children's Court to include guardianship. And the comment was that there must be a definition of a guardian and all that. And we indicated, yes, guardianship forms part of various options for the comprehensive legal solution. And there is a definition for guardianship. So we agree with the comment that has been made. And we also indicated that the minimum age for guardianship is 18 years, and there is no maximum age limit for guardianship. So the courts will always be empowered to issue guardianship orders in terms of Section 46 of the Act. Again, Honorable Chair and honorable members, we indicated that the magistrates' courts will have a jurisdiction over children's court, and that is court matters that may also adjudicate guardianship matters, because the question was whether the magistrates' court can also do what the children's court will be doing in terms of the extended jurisdiction for guardianship purposes. The other comment was around the provision for regulations regarding the role of the registrar and provision for the establishment and resourcing of child care and protection units. For example, the linking of the register to the justice register, and also the register relating to the conduct of the social workers involved, as in terms of the South African Council for Social Service Practitioners. And we indicated that the two registers are actually not linked. So the council, that is South African Social Service Practitioners Council itself, does not have the obligation of screening. Instead, their focus on the professional conduct of their members. So if there is a need to look at such issues, well, we are still busy amending this Social Service Practitioners Act, and also the other part of the Children's Act. So we may still look at that issue when we reach that stage. So all these issues that were commented on relate to that particular conduct. And there was other issue around the implications for the child support grants top up This is an area that we have always spoken about, that the child support grant top-up will be for those who are orphaned but living with their relatives and families who are actually not necessarily in need of care and protection as the rest would be. So this other comment is also around the rationale for having the High Court having exclusive jurisdiction on the matters in Section 45 for a shared jurisdiction on guardianship matters in newly added provision, that is 3A and 3 capital B. And we are saying, yes, that is deliberate because the intention there is not to equate the Children's Court with the High Court, but just to indicate that the Children's Court may have jurisdiction with regard to issues of guardianship, so that at the end of the day, the issue of accessibility is dealt with. And once the issue of accessibility has been dealt with, it becomes easier for the department to have less cases for foster care and all that, because everyone will be, every child will be having a guardian if that gets to succeed at the end of the day. Again, the comment around the issue of guardianship still persists as in terms of Section 24 and Section 25 of the Act. The issue here we are saying is not this particular comment supports the amendment, and therefore we leave it like that because there is no challenge that needs to be addressed. Instead, it further clarifies the role of the department with regard to the issue of the jurisdiction of the that is the extended jurisdiction of the Children's Court to deal with issues of guardianship. With regard to the other comment, is also supported, that is support the issue of the amendment of Section 45 and Section 24 with regard to the jurisdiction that is being extended to include guardianship. And then there is no action from our side that is expected in terms of modifying the current provisions of the bill, because these comments from this particular organization simply support what we are saying, same as the issue of the amendment to the definition of an abandoned child. They support the amendment, and therefore there is nothing that we expect to do. So all what is in this column that is being clarified is to further emphasize that which we have always said as a department in trying to clarify our position as a department. Again, the comment around Section 150, where they say they support the comment where we are talking about the addition where a child has no family member who is able and suitable. So they accept the comment. In that way, there is nothing to do from our side because there is a support of that. Still on that, Section 157, they support the amendment, and therefore there is nothing from the side of the department and the drafting team to worry about in terms of further amending the bill. Again, Honorable Chair and Honorable Members, there is a comment from Nelson Mandela University, the definition of an orphan, where they say this particular definition is not aligned with the National Child Care and Protection Policy, the policy that actually informed this particular bill. We say yes, the definition is not in the Children's Amendment Bill, and the policy are different. But we must understand that these things happen at different times. So at the time of development of the policy, this was a position that was adopted. But as we further engage things change. So at the end of the day, there will be an alignment of the policy with this particular definition. Otherwise, there is nothing to do in the bill itself, but just to take note of what is happening in the National Child Care and Protection Policy. So this particular comment again from this organization also speaks to that there must be an alignment of an unaccompanied migrant child, a separated migrant child as in the policy. And we say, yes, the definition in the bill needs to be aligned. But we must also take into account, Honorable Chair and Honorable Members, that things are not static. As we are developing the bill, as time goes on, there are changes in the legislative market or in the legal settle, in the sense that some of these issues get to be overtaken by events. There are judgments that get to be passed on a daily basis, even on corporal punishment, if I may make an example. As we were busy developing this bill, dealing with issues of corporal punishment, but the Constitutional Court passed a judgment abolishing reasonable chastisement and all that. So in other words, I mean, as we progress with the development of the bill, some of the things do change. So people who make comments need to be cognizant of that. Again, with clause 4, where a question around quality assurance is being asked, whether the Department of Social Development will also have to ensure that they comply with quality assurance when they deal with their processes. Yes, that is the answer that we give because no one is exempted. Clause 6, there is a suggestion that there must be an addition of the definition in section 1 of the in clause 1 of the bill for the sale of children, in order to align that with the 2019 National Child Care and Protection Policy. And we say yes, that will be added. It's one of the issues that we will be looking at. And again, clause 10, around the question of good cause, as to what will determine the good cause. And we are saying we are not actually going to define what good cause is, because the court will determine what good cause is, taking into account objectively all the issues at hand, because these issues will differ from situation to situation. We can't have a uniform definition of what a good cause is. Again, with clause 1, a comment was also made around the addition of family member or relative as to what actually means in terms of this particular bill. And we said we support this particular definition, and the family member or relative to be added after the term caregiver. And again, the issue of that regards paragraph C, which needs to deal with the issue of deleting some words, where we said no, the current definition to be reviewed in order to be in line with what is being suggested for ease of readability. It's not actually something substantive, but it helps with the issue of ease of reading, Honorable Chair and Honorable Members. Again, Honorable Chair and Honorable Members, the issue of us having to consider the privacy and POPIA in terms of what we are legislating on. And we say, yes, we support that, but there is nothing that we necessarily have to do in terms of the bill, because some of these things, they exist by operation of law. These provisions need to be read together with other provisions in other pieces of legislation that exist. It is not the intention of the legislator to rewrite the existing law. But whenever we are dealing with this particular legislation, we know that there is another legislation that deals with a particular topic, which we must read together with this. Again, the comment was for the provision of clear guidance on the evidence required in instances where only one parent is deceased, as the other parent can be the holder of full parental rights and responsibilities. And we are saying, yes, this will definitely be have to be dealt with. That is the strengthening of Regulation 56. So we support that, but it's not necessarily going to be an amendment in the bill itself, but the strengthening of the regulation. There is also a suggestion around the insertion of migrant child after the word unaccompanied in the proposed subsection 1, so that the term is aligned with the proposed definition of unaccompanied migrant child. So we support this, and we say the wording is indeed incorrect in paragraph C. So it will be amended in order to deal with that. The comment around clause 6D, which indicates that the word from another country should be deleted from the proposed subsection so as to align it with the definition of unaccompanied migrant child. And we say there is an incorrect reference to a definition, defined term in the proposed subsection. We say we do not support this view because the word from another country seeks to differentiate between foreign migrants and internal migrant children. Again, the issue of the victim of trafficking, which must be defined or cross-referenced with the Prevention and Combating of Trafficking in Persons Act. We say there is no definition of victim of trafficking in terms of the proposed subsection. So the view is actually not supported in the sense that the proposal is only applicable to that particular legislation. So if we read this particular provision, we need to be cognizant of the existence of that particular legislation, so that these pieces of legislation have to be read together in order to make sense. Again, the consideration of the addition to of the reference to guardians in subsection 1B and A, and then we are saying, yes, we support this issue so that we are very clear in terms of what the guardian is and what we mean by a relation to a child who is under guardianship. Again, Honorable Chair and Honorable members, we need to replace the word maybe with is and delete reason to believe in subsection 1G, which is actually subclause 1G. So we are saying the comment is that the Act is silent on provisions to manage the volume of non-orphans and non-abandoned children living with their relatives. We're saying this view is not supported because we must understand that the probability of harm may be in the future. That is how the provision itself is crafted, and not looking at the construction of a sentence in the present tense form, but in the fashion in which it is crafted. So it's more of a grammatical issue, but we feel that it is okay in that fashion. Again, there is a need to consider the use of the word order, where it is submitted that the word determination is incorrect in the proposed amendment to subsection 5, where we say we do not support this view because the Act does provide for steps to be taken in an investigation. So determination is a process and the court order is the final result. So these things should be construed in that context. Again, the addition of a reference to guardians in subsection 1E, where there is no reference to guardians in that particular section. And we agree with that, that yes, we need to revise that and amend that particular clause accordingly. There is also a need to insert word which is 3 years of age or less, as is indicated in that particular clause, where there is an argument that there is a drafting error in this particular provision, and we say yes, we need to look at that and provide a clear construction of the provision. In clause 10, again, there is a comment that all court orders must be extended by a children's court before they lapse. So consider removing this section and replacing it with a provision that is aligned with the order in the Center for Child Law. We are saying, and the proposition is that subsection 2, capital A, is reactive. Orders must be extended by the court before they lapse. This is not good social work practice, as is indicated. We are saying we do not support this particular view, because this clause is intended to make sure the constitutional rights of a child are not infringed due to systemic and administrative failures. In terms of Section 65, the Children's Court empowers, the Children's Act empowers the courts to monitor and supervise the orders. Because the orders are being monitored, there is no need for those particular orders to lapse at all. That is why this wording is already inbuilt there in the supervision. So this clause empowers the judicial officers to extend the lapsed orders. Again, in clause 14, the replacement of the provision of the word provision with provisions and insert a comma after subsection 1 in the proposed subsection 1, capital A. Yes, we agree with that. We look at that. The other comment was around section 150. And in terms of this, it was indicated that it would be better if Parliament changes the wording from "and has a family member who is suitable and able" to the words "and is in the care of a family member," so that this section takes account of the attachment theory and recognizes existing attachment bond or lack thereof. And we support this particular view, and clause 11 regulations dealing with assessment of children in need of care and protection will make provision to that, because this is in terms of the regulation. Again, with regard to section 159, subsection 2, capital A, which is going to remove the accountability on social workers to regularly review alternative care placements. We are concerned because that is the comment indicating that they are concerned that because it could see the children languishing in CYCCs without permanent planning. And this view is not supported, because when such an order is issued, this clause does not remove accountability of social workers, because when a presiding officer issues an order, it should be accompanied with an instruction to the social worker to submit a report within 90 days. So this is already taken into account. With regards to what the Equal Education Law provided, the reintroduction of what was previously clause 2B, as explained above, a definition of inclusive must be added along with the lines as suggested, and we said we are not supporting this view because it is not within the scope of this bill. Again, the other comment around section 106 subsection 2, we are saying we are not supporting this view because it falls outside the scope of the bill. Same as the comment around section 194 that falls outside the scope of the bill. And comment from the Children's Institute Center for Child Law. We support the views around their comments in subsection 1, in section 1, the definition of an orphan, and the issues around section 24 and section 45, issues around guardianship. They actually support the bill as it is in terms of that. So there's nothing that is expected from us. And again, a comment around section 151A, dealing with children in need of care and protection. The indication is that whilst this proposed amendment is better than the wording in the current act, it is not aligned to the policy in the DSD's cabinet approved national care and protection policy. And we are indicating that we don't support this particular view as recommended as to what needs to be done, because a child who is in need of care, who is in a care of a family member who is unable and unsuitable to care for him or her, should be regarded as a child in need of care and protection. In other words, what we are indicating, honorable members and honorable chair, is that it is not automatic that by virtue of the fact that a child is with the family, then that particular child is not in need of care and family. An assessment still needs to be done from time to time to check whether that child is in need of care and protection. The issue around sections 24, 45, which is about guardianship, which is supported, and then there is no comment that need to be made on our side because it is the person who is making a comment supports what the bill provides for. And again, the recommendation around section 46, that a children's court may make the following orders: that an order confirming or granting parental responsibilities and rights in terms of section to a parent or family member caring for the child. And we say we support this particular view. We will act accordingly and look at how we better craft that in order to be reflective of what is being suggested here by the persons who are making comments. There is also an issue around section 159, subsection 2, capital A, where there is a proposed amendment that there is a need to replace the wording in relation to orphaned or abandoned children placed in foster care with a family member. And we are saying we do not support, the indication is that the commentator does not support in practice this amendment, because this would mean that an alternative court order that has expired can be brought to the court for extension after it has expired. We are saying we do not support this view because we do not need to allow children whose orders have elapsed to remain in care. So that is what we are indicating as a department, that there should be that position, that we should always allow those children to remain in the care of the caregiver. The commentary around section 1, again, you will see that there is a need that there is a substitution for the definition of abandoned child, and stakeholders suggest that the word abandoned be removed in the bill and be replaced with children in need of care and protection, because it is insensitive. And we are not in support of this view because the word abandoned has been defined in the bill. And we must also take into account that child abandonment is also part of our common law system, which is a crime to abandon a child. Yes, it may sound insensitive, but it is the language that is being used out there, which is well in the legal system. And clause 1, again, the substitution of the definition of an orphan where there's a suggestion that the word orphan be removed in the bill and be replaced with child who is in need of care and protection, and this is not supported because not necessarily all the children who are in need of care and protection are orphans. And again, not all orphans are actually children who are in need of care and protection. So there is a distinction that must be drawn between these categories of children. Again, Honorable Chair and honorable members, the view around that is clause 1 again, guardianship, which indicates that that for no apparent reason, that is the construction of the definition of a guardian, where we indicate that is enough an abandoned child, where we indicate that for no apparent reason the child has not been in contact with the parent, guardian, or caregiver. We are saying this is not supported because 3 months is sufficient to allow the social worker to investigate. When it was indicated that 3 months is too long. Not that nothing will be done within an hour, 2 hours, 48 hours during the issue of abandonment, but it is not that the social workers will be waiting for 3 months to do that. Again, the commentary around sections 24 and 45 would support that which we have dealt with, and the issue of the removal of children who are unaccompanied and from outside the country and who must not form part of the system, that is unaccompanied or separated migrant children. And we are saying we do not support this view that these children must be sent to detention centers and be extradited as it is suggested, because it will be unconstitutional to do so as per the cases that we have already had in the past, that is learning from such precedents. Again, with the issue of the stakeholders who support the amendments around sections 24, 45 and 45.1 and 45.3. Yes, we support that because they are around, these are the issues around guardianship. So they are in support of that, and nothing is expected to be done in terms of this bill. The amendment of clause 6 in section 150 of the Act, where the indication is that clause 6 as amended so it is suggested that the sentence does not have the ability to support himself or herself, and such inability is readily apparent. So these words should be removed, and we are not in support of this particular view, because a child who is in the care of a family member who is unsuitable and unable to care for that child is a child who is in need of care and protection. The challenge around this particular issue, honorable members and honorable chair, has been this fear that if a child is orphaned and the child is in the care of family members or relatives, then that child will be ignored by the department in terms of the services, which is actually not true, because that child will still be assessed from time to time to check whether that child is still in need of care and protection, so that other services can be able to be organized for that particular child. The amendment of clause 8 in subsection 1, honorable chair, honorable members, the stakeholders suggest that if the intention behind the insertion of subsection C, capital A, was to cater for the need to formalize the care arrangements of orphaned or abandoned children living with families, it would be better to make an amendment to section 46, subsection 1, which deals with all the orders the court has. We are saying yes, that particular provision is correct. Section 46 it should be crafted like that, but at the same time, there is a need for that section 160C capital A in order to deal with the how part of it, which is the regulations that are envisaged in that particular amendment. So we support that view that section 46(1) and 160C capital A should be read together in order to make sense at the end of the day. With regard to clause 9, which is the amendment of section 157 of the Act. So the public was of the view that the period of 3 years or less as an element of discrimination against older children. It was indicated that the difficulty might happen in case of older children. So the period has to be extended to at least school-going age of around 6 years. So the amendment of section clause 9 in section 157 of the Act, which is intended to amend subsection 21, will include the words limited period to allow reunification and all that. This view is not supported, Honorable Chair and Honorable Members, because the period itself is enough for the department to be able to deal with what it needs to deal with, having taken into account what has happened in the past and the practice, how successful the cases have been relating to that. With regard to the amendment of clause 10, Honorable Chair, Honorable Members, there is a need for a legal requirement of 2 years reports that social workers need to take into account. And this is why the Department of Social Development has been chasing an unsolvable backlog for 10 years. That is what is being indicated by the persons who are making comments. And we have taken note of this comment, but we are saying the department is implementing the proposed strategies in terms of this in order to avoid the backlog that we were talking about in terms of what exists at present. With regard to, still with regard to section 159, where there is an indication that the amendment of section 159 to include subsection 2 capital A is not supported, and there is a recommendation that it should be removed. We are saying we do not support this because the extension of loved orders will allow children to remain in care. So we do not support that which is being proposed in terms of this particular provision. Again, Honorable Chair and Honorable Members, with regard to the other comments relating to 159, in fact to 185, that is the amendment of section 185 of the Principal Act. The view is that the bill in respect of section 185 of the Principal Act, in particular the submission for subsection 2, the substitution of the word more with the words not more than 6 may be placed in foster care with a single or two person or two persons sharing a common household is problematic for the African family children. So these words not more than is an element of separating the siblings. And we are saying, yes, we understand the concern, but people when reading this particular bill must also understand that there is also the Principal Act dealing with these particular issues. Because in terms of section 185 of the Principal Act, if children are siblings, then those children may not necessarily be separated. But if these children are just from different families, then they cannot be more than 6 if they are in that setup of a foster care system. So with regard to the amendment of clause 14, which is section 186 of the Act as inserted by section 10 of Act 41 of 2007, the stakeholders suggested that if Section 159 is reviewed more than once, then the foster care placement can be permanently placed in terms of Section 186. And we say, yes, the Act makes provision of transfer into alternative care. That is what this whole system is all about. That is why the social workers have from time to time deal with issues of regular checkups and monitoring of the situation. And the issue of children writing exams who do not actually have birth certificates and all that, we said this is one of the issues that we are worried about is the department, but Department of Home Affairs is the one that regulates this space. So we need to escalate this particular issue to the Department of Home Affairs and ensure that no child goes to an exam room without a birth certificate. So this is also the comment that the Refugee Legal and Advocacy Center also proposed. It is a huge challenge with regard to what needs to be done. With regard to the same comment in terms of the whereabouts of a child, of a parent that are unknown, it is indicated that this is burdensome to play for a child to say the parents are unknown and the whereabouts of the particular parent are unknown. We are saying, yes, we support this particular view, but we must take into account that we are saying with regard to the child support grant top up, if the whereabouts of the other parent are unknown, then that child can simply, or the person applying on behalf of that particular child can simply submit an affidavit to that effect, so that at the end of the day, the child can have the necessary services that are required. So the definition again of abandoned child, where we we have been supported, we say yes, it's okay. We are not going to focus on that because we are being supported. But now the expanded definition of adoption service, which provides for aftercare services for the adoptive family, we are saying that falls outside the scope of this bill. We are not going to look at it at this stage. Not that we are saying it is inferior or unnecessary, but because it falls outside the scope of this bill. We are still going to consider it when we consider the other bill that is still to be introduced by the committee. The issue of the definition of an orphan, which will be used mostly with regard to Section 150 to ascertain whether a child is in need of care and protection. We are saying we do not support this particular view, that the definition will be used in that context. So the bill provides for all kinds of offense, not only double offense. So we are trying to move away from the scenario where we used to focus on double offense. Again, the definition of social service practitioner, the expanded definition of social service practitioner clarifies the relationship between auxiliary service social workers, the child and youth care workers, community caregivers, and social workers. We say that is correct. We support this view. Indeed, that is the case. And there is another issue around the definition in the UN Convention on the Rights of the Child that does not include the word citizen, the inclusion of both documented and undocumented migrant children. So the specific wording of the proposed edition is exclusionary and will in effect exclude children who are not citizens. And we are saying we do not support that view. The bill makes provision for all children to be protected irrespective of nationality, because the Constitution is very clear. It does not say every South African child, it says every child. and every has been interpreted by the Constitutional Court in many instances to mean every, as in the context of everyone within the borders of the Republic of South Africa. Again, Honorable Chair and honorable members, the MEC for Social Development must set aside money for partial care from the monies appropriated by Parliament for that purpose. We say we do not support this view because it is outside the scope of this bill, same as the amendment of Section 78, which is not outside the scope of this bill, Section 79 outside the scope of this bill. And with regard to the insertion of the words children's court under Section 24(1) from the Free State Province, yes, that is supported. And again, clause 3, which is the amendment of Section 105, the new inclusions, 1B capital A, guardianship of a child as contemplated in Section 24. Yes, that has been supported. We'll look at that with all the suggestions that are underlined there in the matrix. With regard to the amendment of Section 105, the department must, as prescribed, develop and conduct this. Yes, it's already there. It has been supported. We agree with the support because this is already provided for. And with regard to the amendment of Section 150, there is a need to align with the policy. We are saying we do not support this particular view that is regarding a child who has a family member who is able and suitable to care for that child. Hence, we have removed that. We say a child who has no family member who is unable and unsuitable to care for the child is a child in need of care and protection. I think we have always been re-emphasizing this, Honorable Chair and honorable members, from time to time, to say not a child who is with the family member or relative is not necessarily a child who is who may be ignored by virtue of being with the family members, because that child may still be in need of care and protection after consideration has been taken into account. The issue of 90 days period which the social worker within which the social worker has to submit the report is indicated to be too long, and a 60-day period is being suggested. And we are saying we are not in support of that because 90 days allows the social worker to conduct a thorough investigation. And it may be difficult for the social worker, to do that within 60 days, and may be a challenge. The amendment clause 8 in relation to Section 156 of the Principal Act, with the addition of the word care and removal of the word control. Yes, that one is supported, and we will act accordingly, and also take into account those that are the words that are underlined, which are add-ons in terms of what has been suggested. But we must also indicate, Honorable Chair and honorable members, that when we agree to amend as suggested, we'll still have to read the provision in its entirety and see if the reconstruction will not change the wording altogether. But in principle, we do agree and support. With regard to clause 10, again, Honorable Chair and honorable members, a court may extend an alternative care order that has lapsed, or make an interim order for a period not exceeding 6 months on good cause shown. And that is a suggestion, and we say we have noted that, and that is actually what we have said with regard to section that is clause 2 capital A and clause 2 capital B. Again, Honorable Chair and honorable members, the issue around the inclusion of the words as underlined in section 1592 capital A, which we will take note of and reconstruct our provisions in order to read well and include what has been captured in those particular provisions. As the department has taken note of that and is in support of that. Again, with regards to clause 11, the suggestions around the inclusion of section 160C capital A, the procedure, the form and manner that a social service practitioner must follow when assessing, screening and investigating whether a child is in need of care and protection. Yes, that has been supported. We accept that, and it is in line with the comment that was made earlier around section 46, subsection 1, which also has to read in that fashion. With regard to the amendment of section 185, the need for the substitution of the word not more than 6 may be placed in the foster care system, and the use of the word not more than 10. And we are saying no, 10 is too much, and then we do not support that 6 is a number that the department sticks with because it will be problematic. And we must also take into account that with this particular case scenario, we are also avoiding a case where people make money out of these children. Where they say the more children you have in your foster care system, the more money you get. At the end of the day, these children do not get anything from the money that is meant to be for them. So once we allow the number 10, that will be too much at the end of the day. Even 6 itself at present is too much, but it's the figure we can live with. But 10 is very much. Again, with regard to clause 14, subsection 1A and 1 capital A, in section 186, the suggestion that there must be an addition as underlined there. Yes, that is supported, Honorable Chair and Honorable Members, because these are already in the bill. As I indicated earlier, that you will understand that some of the comments are relating to issues that we have already taken into account. The short title, the comment thereof is supported. The other comment around that from the KZ and province, a child who has been abandoned or orphaned and is not in the care of a family member as defined in section 1. Yes, there is a support of this intent, but at the same time, we need to have that properly crafted in the bill. Yes, that is accepted. The comment is supported, and we also support the comment as in section 46, subsection 1 of the Principal Act relating to an order confirming or granting parental rights and responsibilities. Yes, we support this particular view as we have crafted the bill along those lines in that particular area. And we'll also relook at it in order to ensure that it does capture exactly what has been suggested. Again, the comment around the duration and extension of alternative care orders, section 159 relating to the orphaned or abandoned child who is placed in foster care with a family member. A court may make an interim order of an extension of an order for a period not exceeding 6 months if such an extension is required to ensure continued receipt of a foster care grant. So the extent this can be extended to a period of 3 months. That is, it must be done before in order to ensure that this child does not lose at the end of the day. And we are indicating that we do not support this view because in practice, this amendment excuse me. This amendment would mean that alternative care court orders that have been have expired can be brought to the court for extension after they have expired. So we have taken note of that, and we say we do not support this particular view because the crafting of this particular provision seeks to ensure that this is how we need to deal with this. Again, some of the provisions that were commented on around the amendment of section 45 and 24, which were supported. Yes, these provisions, that is clause C from the first clause, clause 3A, clause 6, clause 7, clause 10, were supported by the province, and where the comments were made with regard to minor changes were taken into account of that, and we are of the view that yes, such will be noted at the end of the day. With regard to clause 1, there is no proposed amendment from the province, and this clause seeks to amend section 1 of the Principal Act by substituting and inserting new definitions for abandoned child, cluster foster care scheme, social service practitioners, and orphan. So the definition of an orphan in the Principal Act is the normal definition. So these provisions were actually supported. And then there were no proposed amendments with regard to clause 2, no amendments with regard to clause 3. And that is the one that speaks to issues of guardianship and the extension of the jurisdiction of the children's courts, and no proposed amendment with regard to clause 4. But with regard to clause 5, the proposed amendment is that a criteria be added for persons to be appointed as registrar and instances where they can be removed from office. So this clause seeks to amend section 142, and we say yes, that is actually the issue, because when you look at the regulations that we currently have, the minister will have that power. So we support this particular view as proposed because it speaks to what we already have in our regulations. With regard to clause 6, the proposed amendment is the deletion of such inability. The word such inability is where inability is readily apparent. And the indication is that this clause seeks to amend section 150 to clarify that a child who is abandoned or orphaned and has no parent or guardian or caregiver who is able and suited to take care of that child. I'm saying yes, that is correct. We agree with the support that we receive with regard to that, because we have crafted this provision in line with that thinking. With regard to clause 7, there is no proposed amendment, same as clause 8. There is no proposed amendment. Clause 9, clause 10. No proposed amendments. Also, when we look at clause 11, the proposed amendment is that there is a need for an insertion which provides that a child's right to privacy and protection of personal information is subject to several acts, including POPI, the Films and Publications Act. They say this, and the indication is that this clause seeks to amend section 160 by providing that the minister may make regulations regarding the procedure and the form. So we say, yes, we agree with this. That is exactly the intention of this particular provision. But these provisions must be read together with existing pieces of legislation, but not necessarily be seen as duplicating the existing legislation in this particular bill. So there is no need to amend any part of this bill, but we need to take into account that there is such legislation that exists. So the other comment around clause 12 is that this may give an additional administrative burden on organizations. So it is suggested some assistance be provided to organizations to ensure compliance. So we say this clause 6 to amend section 183 by providing that an organization providing or managing the cluster foster care scheme must register as a designated child protection organization. And we have indicated earlier, yes, that we agree that these organizations must be registered as designated child protection organization. So there is actually nothing to add in the current bill, as that has already been taken care of. With regard to clause 13 and 14, that is clauses 13, 14, and 15, there are actually no comments, Honorable Chair and honorable members, from this particular province. And in that way, there is nothing more we can do in terms of amending the provisions of this particular bill. With regard to the comments from the Western Cape province, and also the Center for Child Law, and all that, the amendment of section 151 capital A, child who is in need of care and protection, and the children in need of care and protection, how these provisions have been crafted. The comment has been that, yes, these provisions are supported by the province, and there's actually nothing to add with regard to this, but there is also a need to align these provisions with the policy, that is the child care and protection policy, as has been approved some time ago. So these are the comments that they have made to remove some of the wording, like the child does not have the ability to support himself or herself, and such inability is readily apparent, and the child has no family member and all that. And the indication is that whilst the proposed amendment is better than the wording in the current act, it is not aligned to the policy position. As I indicated earlier, that yes, as things happen, as days go by, what was approved in 2018 in terms of that policy has changed now that it is 2022. So we need to revisit such cases and see if we cannot amend the policy itself so that it talks to the current scenario. So the commentary, in fact, is being has been supported. Mostly the provisions of the clauses from the bill itself have been supported, but with some minor issues that have been raised in order to look at the reconstruction of these particular provisions. And we have accepted that approach, that yes, we will look at the reconstruction of the provisions of the bill to speak exactly what this bill intends to achieve at the end of the day. With regard to sections 24, 45, and 45 sub 1 and 45 sub 3, yes, the organizations in the province have supported this issue of guardianship, that indeed it is important that we extend the jurisdiction of the Children's Court so that the issue of guardianship can be accessible. With regard to the amendments to section 156, there is a recommendation that we also need to align this with section 46(1), where the Children's Court may make the following orders, and has been cleared out in the document. and also that orders can that a court can make after finding a child is in need of care and protection. So we need to look at that as to what exactly the court can take into account. And this must be read with sections 160C capital A, which is also going to look at the issues of assessment as to whether a child is in need of care and protection, so that before a child can have a placement order, this particular option can be made available by the courts. So the social workers will be able to work on that so that they can also look at issues of reunification instead of placing a child first in the foster care. So they will be looking at various options, reunification, adoption, and all that, and foster care be the last in the line of things to be done, or the options to be considered, to be precise. With regard to section 159, the indication is that there are 3 options to solve, that is reduce the number of children in the foster care system, double the number of social workers, and change the foster care system from a system for children in need of care and protection to a system for children in extended family care. So the indication is that option 1 is being given effect to by the child support grant, top-up grant, and option 2 has been pursued all along by DSD, and option 3 is being partially put into effect via the amendments to section 159 and 186. And the indication is that, yes, we do support this because this is actually talking to the intention and the spirit and the purport of this particular bill. So the province and the stakeholders in the province are actually in support of the proposed amendments. And then with regard to section 1592 capital A, there is a need to replace the wording in section 2 capital A, subsection 2 capital A, in relation to orphaned or abandoned children placed in foster care with a family member. A court may make an interim order as indicated here, extend the order for a period of 3 months on good cause shown. And we say, yes, exactly what this is, what is being proposed is what the bill seeks to achieve at the end of the day. So the comment itself is actually in support of the bill. And where there is an indication that the wording has to be recrafted in order to achieve the purpose of this particular bill, the drafting team will work on that. Otherwise, this is in line with what has been presented as the mandate from the respective provinces. With regard to capital B of subsection 2 of 159, the organizations proposed the amendment to that in order to protect children who are already in the foster care from losing their foster care grants once this bill becomes an act. And the indication has been that, yes, it must be remembered that this bill ordinarily will not be operative retrospectively. It will only take care of the cases moving forward. And those children who are already in the system will not be disadvantaged by the coming into force of this particular legislation. And with regard to section 1, which is clause 1 of the bill, and clause 2 dealing with sections 45, 24, and also the subsequent clause that deals with section 45, that has been supported. And also the definition of a child in need of care and protection, and as in section 150, then that has also been supported because every provision that deals with the child who is in need of care and protection must also be read together with every other provision that we are trying to deal with in this particular bill. The orders that are being referred to when a child is found to be in need of care and protection, this has been supported with additional amendment, and the additional amendment that we have looked at simply seeks to make further clarity. So we intend to reread that provision and see if there is something that we can add, but ordinarily, as we have put it in that fashion, it seems as if it is already capturing what the commentary seeks to achieve at the end of the day. With regard to the extension of alternative care orders, again, there is a lack of support in this particular, for this particular provision, because the indication is that in practice, this amendment would mean that alternative court orders that have expired can be brought to court for extension after they have expired. So this will affect the 16,000 children. And we are saying we are not in support of this particular view as a department, because the manner in which the provision has been crafted in section 159, subsection 2A, is in such a way that these orders must be extended before they expire, as indicated, not after they have expired. Hence, we even have the monitoring system as a department to track and trace the status of these particular orders, so that at the end of the day, we are aware as to at what stage this particular order is, so that it gets to be extended in good time. The issue of the definition around the prevention, the issue around the prevention of offense has been indicated, and the foster child support grant and the top up that is supported. So there's nothing expected from our side. Still within the Western Cape, Ilita Labantu, which takes note that this is provided for in section 151A, that a child who is in need of care and protection is, as indicated in that particular provision. And then the definition is welcomed, but there's a concern that other vulnerable children might be left out. And we are saying that is not going to happen, because social workers will always be there to monitor the situation and also assess every case scenario. That is why we have section 160C capital A to have the minister making regulations in order to determine whether a child is in need of care and protection at all times. So the concern must not be taken into account very much well, because there are systems in place to deal with that. And the other recommendation is that the NGOs who have adequate appropriate skills and expertise be reconsidered, empowered to make assessments and reports. Yes, we take into account that, but unfortunately, we don't have to worry ourselves much with regard to this, because we can't make it a law that NGOs must be considered, but from time to time, they will prove their case through the supply chain management systems in government, rather than to make it a law that the department must consider them. Again, with regard to section 24, the issue of guardianship, assignment of guardianship by court, any person having an interest in the well-being of a child. Yes, that is true. The regulations and the guidelines will deal with such cases as to who exactly can be a guardian under the circumstances. With regard to the issue of not more than 6 children being placed in foster care, that is welcomed, and then that is important for us because it actually supports our cause, and therefore we do not need to have any provision to make. With regard again to another NGO that has also applauded the inclusion of unaccompanied migrant children in the amendment, particularly in section 150. However, they argue that regulations in respect of the procedures for practical realization of the inclusion of these children be published. Yes, the department is in the process of finalizing those regulations, as that they are tailing just behind these provisions, so that once this bill is passed into law, there will be no huge time lag between the finalization of those regulations and this. So we accept the comment and say we are exactly working around that. The other comment from Molo Songololo, they support the amendment with regard to the issues of guardians and abandoned children, and also the offense as contemplated in clause 1 of the bill. And again, they are suggesting that there must be some words added with regard to the definition of abandonment relating to guardian, or the addition of the word guardian and the additions of the word, and determine that the child has no care, supervision, and support from a parent, guardian, or caregiver. We say we take note of this particular suggestion, but we feel that these words are actually being read in already in the definition that we have. If a person reads closely at the definition that we have brought, one would find that it does include what is being suggested. So this suggestion is actually in support of the proposed amendments that we have made in terms of this bill. Again, there is a support for the new definition. The new words that have been included, that a child who is abandoned is a child who has no knowledge of the whereabouts of a parent, guardian, or caregiver. We accept that and say, yes, indeed, that is exactly what we have provided for in this bill. With regard to clause 2 of the bill, is all about the children who are orphaned or abandoned, who may be in need of care and protection. And now the indication is that this clause states that caregivers who are not foster parents can make legal decisions about an orphaned or abandoned child. And now the question is how that can happen. But it must be remembered that the court will have placed a particular child under that particular parent or caregiver, and the court order itself will spell out what powers that particular parent has. So that answers the question as to how will that happen. So whoever will be applying for that particular court order will have to explain or sought clarity from the court as to what powers does that particular person have. With regard to clause 4, the issue of SAPS not assisting social workers with the removal of children and not assisting with behavioral challenging children. Yes, this is one of the challenges, but we said this is an intersectoral issue that needs to be dealt with, differently in terms of the other bill that we are still to present before yourselves, Honorable Chair and Honorable Members. That is the bill that has got the rest or the remaining provisions relating to children. With regard to issue that foster care is not an option. Social workers need to write a report and submit it to court. The indication is that we are saying that the social workers, yes, will have to make a recommendation at the end of the day, whether foster care is the option that is desirable for a particular child, or look at other issues. With regard to clause 6, the issue of foster care and guardianship and the issues of decision making and the issues of top-up grant. And the question is, how will it work with the means testing that will still be available, and the reluctance and resistance of family members? And we are saying a child who is orphaned and who has a death certificate or death certificates that one can submit for the top-up grant. Yes, that particular person can, or that particular child will benefit from the top-up grant. And the issue of clarification of cluster foster care parent versus foster parent, is there a difference? And the issue is that, yes, there is a difference in the sense that one has got is just a parent having a foster child, and the other one is in a foster care, is a cluster foster care scheme, and the roles and responsibilities that emanate from those two setups are different, because the other one is in a family setup and the other one is not necessarily in a family setup, but in an institutional setup. That is the understanding. Again, the issue of adoption must be clearly defined with regard to section 230. How can social workers determine that a child does not require foster care? What will be the deciding factors? We say the social workers are capacitated enough, they are schooled in that area. They do understand what it means by determining whether a child is in need of care and protection. So we should not worry ourselves about that. Otherwise, we may also need to wait for the regulations, more especially in terms of section 160C capital A, which will be talking about the screening, assessment, and investigation, which at the end of the day will be talking about those determining factors that are being asked in this regard. With regard to clause 11, there is also a comment as to why only 6 children are allowed under one roof in a cluster foster home if there is a space to accommodate, if there is ample space to accommodate more children. And we have responded, honorable members and honorable chair, to this many times to indicate that what is more important, again, we're also trying to ensure that the issue of foster care is not made a money-making spree by ensuring that a person has got as many children as possible in order to make money out of that. It must be a genuine kind of a transaction that seeks to ensure that a child gets what he or she deserves. That is the clarity that we are giving with regard to that. And again, with regard to clause 13, there is a statement that social workers will make a recommendation in terms of section 186, but the presiding officer will just extend for a period of 2 years. Now, let us define and describe the child protection unit and quality assurance unit. How will this be put in place in practice? Yes, these are actually the issues that will be dealt with under the regulations, because we do say as prescribed in the bill. This is where the wording that exists in the bill, that this will be as prescribed, meaning that it will be going to the regulations at the end of the day to unpack exactly that. and the issue of the magistrates or the presiding officers who will only just extend for a period of 2 years. Yes, they will be looking at various factors and will determine what is the best course to take. We cannot venture much into that space and dictate to what the magistrate, I mean, the presiding officers should do, because we might be seen as going for some judicial overreach, of which that is not the intention of the legislature, but to give the other arms of government enough space to do their work. So we cannot necessarily answer that question and say, what if the magistrate, the presiding officer, gives 2 years instead of up to the age of 18, as the cases will differ from each other, taking into account all the scenarios before the presiding officer. So there is also a need to clarify on what happens in the case where a parent has alienated a child or abandoned the child without informing the other parent. So in these cases, we are saying, yes, we are mindful of such cases, but those will be dealt with as the investigations will be taking place in terms of Section 160C capital A regulations. And if there is a proof of abandonment or such alienation, the consequences thereof will ensue. With regard to the case from Mpumalanga province, the inputs by South African local government in line with Section 154 of the Constitution, which states that national governments and provincial governments by legislative and other measures must support and strengthen each other. Now the issue is about clause 2B, item 2, which has got a direct implication on municipalities and SALGA, which indicates that SALGA should be allowed to follow the internal governance procedure to ensure ability to deliver on the extended requirement due to the definition of early childhood development and the issues of facilities. We take note of this particular comment and we indicate that we must take note that ECD has already been transferred with effect from 1 April this year to the Department of Basic Education. So this falls outside the scope of this bill. Again, the inputs relating to the this particular amendment bill, the issue of parental responsibilities and child marriages, we are indicating that yes, adoption, funding of partial care centers, all these issues that are being raised by the municipalities are very important, but unfortunately, they fall outside the scope of this bill. Same as those that have been presented by Nkangala District Municipality, because they are also talking about the issues around ECD, intergovernmental relations framework, how this organs of state in different spheres of government should assist each other. And further than that, they are talking about the shortage of social workers and the fact that there is no social development office in their area, which then would speak to the other bill that we need to finalize with the committee at a later stage. So we appreciate these comments from these municipalities. Gertrude Sebande is also of the same view, and the community of Nhlanzeni is also talking about the rights of unborn children and issues of abortion and fathers that should be permitted to be part of the child's life. And we are saying these issues are actually not part of this particular bill. Some of them are part of the bill that is still to come, especially the rights of fathers that are unmarried. So those will be part of that. Again, Honorable Chair, with the comment around Dear South Africa, you are saying the comment falls outside the scope of this bill. So we don't need to worry ourselves about it at this stage. Again, I must emphasize that not because it is not of value, but because it falls within the ambit of this other bill that we must still work on at a later stage. So these comments that fall outside the scope will have to wait until the committee publishes that is the remainder of the Children's Amendment Bill will be publishing the remainder of the bill, so that at the end of the day we can entertain the rest of this. For example, the issues of corporal punishment, which are not part of this bill, as has been presented by the stakeholders. You will understand, Honorable Chair and Honorable Members, judging from these issues, that there are key emerging service delivery issues that have been raised basically by the stakeholders throughout the country. The message is common mostly. It relates to some of the issues that are in relation with this particular bill. Some of these issues are not in relation with this bill. So you will note that they've raised issues around the top-up grant, which we have tried to respond to, the issues of guardianship and the issues of the age of majority, which form much of the content of the other bill. The issue of quality assurance, which is part of this bill, the school for social workers and unregistered facilities, which speak to the other bill, the recognition of traditional leadership, children roaming the streets, children's access to alcohol, which belongs to other pieces of legislation, because we still have the Prevention of and Treatment for Substance Abuse Act to deal with such issues. The children abused in school premises and undocumented children and foster care. So basically, these are the issues that have been raised: the parental rights and responsibilities, drug abuse and abuse among children, protection of children, teenage pregnancy, which is a challenge, abuse of children's grants, abuse of disability grants. You will understand, Honorable Chair and Honorable Members, that most of these issues, as have been highlighted here, are mostly issues that talk to service delivery challenges on the ground. Some form part of the bill, some do not form part of the bill. But we have been able to look at those and try and locate those that form part of this bill and respond to, and also taking into account that we'll be keeping the rest for the purposes of the other bill that we'll still continue with. So in conclusion, Honorable Chair and Honorable Members, we have taken note of the fact that all the 9 provincial legislatures concluded their public hearings successfully and have presented as they did before this particular presentation. And most of the challenges that were raised were on service delivery. But we are happy that the provincial legislatures have supported this bill, and where they've made comments, we are going to amend accordingly where there is a need for an amendment. Or just to clarify, because some of the comments are not more additional to the bill the way we viewed them, but we have taken them to understand that there is just a need to to craft the provision in such a way that the reading is very clear. So we will be embarking on that exercise shortly, Honorable Chair and Honorable Members, as a drafting team. And I thank you, Honorable Chair and Honorable Members.
Thank you very much for that briefing into the public participation process. Members, I will allow the parliamentary legal advisor and the state law advisor to make their inputs. And maybe I know a lot of you are now having a question, what is the other bill referred to? I will leave it over to Nati, who will also answer that question that is in your minds. So without further ado, I will hand over to the parliamentary legal advisor, which will follow by the state law advisor. Thank you. You can continue, Nati.
Oh, thank you. Thank you, Chairperson. Can you hear me clearly, Chair?
Yes, I can.
Thank you, Chairperson. Chair, I just have to comment in relation to what has been presented by my colleague, my learned colleague from the DSD, Advocate Mchochisa. A detailed commentary on the bill and the responses to input from public participation. Chair, we, as the legal team that has been working on this legislation from when it was introduced in the portfolio committee as to all the way up to here where it is now, it has been the department itself, who are the implementers of the legislation, and specialist subject matter specialists, working together with the Chief State Law Advisor's Office, who are specialists in the drafting, working together with us, our office at Parliamentary Legal Services, in order to bring some legal support to the process of considering this legislation by Parliament. This process, Chairperson, is going to continue as from where I have just explained, where as legal advisors we are going to be working together to consider the mandates that have been put before the committee by provincial legislatures, and together with the responses together with the input by members of the public, as well as the responses to both those by the Department of Social Development. The next step now, Chairperson, is going to be for us to look into all of those documents with the purpose of coming up with a list of committee amendments, which is going to be the C version, Chair. A list of committee amendments that will arise from the committee deliberating on the information that is currently before it. The information before the committee being the Principal Act, which is the Children's Act, the bill that has been referred from the portfolio committee or from the NA to the committee, the input from the public, the mandates from the provinces, as well as the responses that have now been spoken to by my learned colleague, Advocate Mchochisa. From this process, Chair, we will be taking information so that we can go as legal advisors and drafters to go and develop a list of committee amendments. That list, Chairperson, is going to be one where we will be directed by the committee on what to amend based on the input from the public. If the committee is agreeable with the input from the public and the responses from the department, we will be developing that list. But of course, where there is a need for us to advise technically on the drafting and where matters we feel, Chairperson, are going to not going to be sound in law, we will provide advice on that as well, Chair. when we provide that C list, which is the draft list of committee amendments. Subsequent to that draft list, so I'm just outlining the process, Chair, of what's going to be unfolding henceforth. So subsequent to that C list, if it is agreeable in the committee, we will go and incorporate the C list to the bill as referred to the committee in what is going to be the D version, which is the version of the bill that incorporates all of these changes, deliberations of the committee, as well as the recommendation by the committee to us drafters to include into the bill. So that will be the final bill, the D version that is going to be accompanied by a committee report on this bill, which will then be referred to the House Chair. So the committee report attaching the bill will then be referred to the House, will first be published and then be referred to the House for the House to consider. So that will conclude the work of the committee, Chair. On the issues that have been raised by the department in respect to matters that they support and matters that they don't support. Chairperson, members would remember that this bill comes as a result of a High Court judgment, Gauteng High Court judgment, in which the court decided that there needed to be amendment in legislation to provide for substantive or extensive foster care parenting. So that is the context of this bill, Chair. This is why you hear Advocate Mtshotshisa sometimes when presenting, saying that the matter falls outside of the ambit of this proposed legislation. It is not that the matters being raised by the public, Chair, are not relevant in relation to the matters of children in general, but they are not relevant to the extent that this bill is one which responds to that High Court judgment in the Center for Child Law against the minister, where the court decided that Parliament needed to provide for extensive foster care parenting. So from the input of the public, we are isolating all of those matters which relate to foster care parenting, and those are the matters that will see their way into the C list. And then, Chairperson, the valuable information, general and wide-ranging information relating to the entire field of regulating of matters children. All those matters, Chairperson, are going to be matters that are going to be collated into a document from the committee, which we will table before the committee, having isolated the general matters relating to the issues of children. We would do so, Chairperson, because at the portfolio committee level, the committee had taken a decision to say that much as the bill that was introduced by the department before them was wide-ranging, covering all manner of matters relating to children, there was a need for those matters to be separated so that the bill is specifically focused on matters relating to foster care parenting. And that the rest of the general matters relating to, as much as they're important, relating to children in general, would then form part of a committee bill, Chairperson. So there is a decision by the portfolio committee, Chairperson, to develop a children's amendment bill, which will deal with all matters, general matters relating to children. And Chair, all these matters that have now been put, the valuable information that has now been put before the committee, will not fall away or be not considered. It is just that, Chairperson, in this amendment process, the committee is focused on amending legislation in order to provide for extensive foster care parenting. And therefore, that information we will develop as legal advisors, Chairperson, and put it together in a document, which document the committee may decide, if it feels it is necessary, that it must be referred to the committee which will be responsible for developing the committee bill, Chairperson, that will deal with all the matters, all the broad matters and wide-ranging matters covering the field, regulating matters children. Chairperson, that is essentially my response to the presentation by Advocate Mtshotshisa, and that if there's anything that I may have left out, please do, Chairperson, raise that matter so that I could respond to it. Thank you.
Thank you, Nati. The state law advisor is still in the meeting.
Yes, Chair, I'm present.
Hi, Ms. Naidu. You can continue with your input.
Thank you, Chair. Please forgive me, honorable members and Chair, I did not introduce myself earlier, It's now gone into the evening. So good evening to everyone. I'm Lisa Naidu from the Office of the Chief State Law Advisor. I am in agreement with the Parliamentary Law Advisor. I just want to emphasize that at the Portfolio Committee, the department introduced a bill that covered a wider area. Because of the constraints we have with time and meeting the timeline for the court order relating specifically to foster care system or a comprehensive foster care system, the decision was made to separate the bill, where what you have before you is only the foster care provisions and all the other provisions go into a committee bill. Advocate Mshoshiza did a presentation, and even though the wording says not supported, I need to clarify that that is not supported in relation to the bill that is dealing with the foster care system. However, like my colleague Nati indicated, it will be considered and it will be incorporated in the committee bill, and it will follow the process of going for public consultation once again. So it's not as if the department or us as legal advisors are discarding any advice or any inputs that were given. Everything is going to be taken into consideration. But for the purposes of this bill dealing with the comprehensive foster care system, whatever has been supported, the legal team will redraft accordingly and present it to the committee, and we will move from there. That's the only emphasis I wanted to bring in. In addition to that, from the legal advisor side, that's the Parliamentary Law Advisor and myself, our main function is to ensure that when we revise the provisions in this bill relating to foster care system, it must be constitutionally sound and it must be drafted in current drafting practices. The department's responsibility is entirely relating to policy and pushing policy on the foster care system. And Chair, I don't want to take too much of your time. The Parliamentary Law Advisor covered the process. I'm not going to repeat that, but thank you for allowing me to speak, and I will assist the committee in any way possible.
Thank you, Ms. Naidu. Members, there you have it. Let me just explain what will happen after this meeting. The minutes of this meeting will be forwarded to all legislatures as soon as possible in order for legislatures to formulate a final mandate to be presented at the meeting scheduled for the 8th of November 2022, in which this bill will be finalized. I will now allow any member for any input or question of clarity. You can raise your hands, members. I don't see any hand. So let me then take the opportunity, sorry, to thank Member Nkosi before you can continue.
Thank you very much, Honorable Chair. Thanks also from the department, the presentation that they've made, and also the legal section or department that they've made their presentation. Honorable Chair, one must start by thanking the department for conducting well the public participation. You could hear or you could see when all the provinces are coming forward with their mandates, that indicates very clear that all provinces were managed to do their public participation very, very well. and we must applaud them for that. Chair, I think on the presentations that the department have made, I heard about a number of comments that were made by the people that were there in the public participation or the province. That indicates I think the comments that were made or the inputs that were made outside the scope of the Children Amendment Bill, of which we accept that because they must do that if they wish to do. But what I would like to say, or I would like to request as the member, is that with those comments that they've made that are outside the bill, I propose or I request that let those comments be noted and request the department to deal with them and deal with them outside this amendment bill, because they are not part of it. But we very, very thank them for bringing them to our attention that there are these comments that they've been made that are outside the amendment of the children's bill. And we really thank them and accept them. But I propose that let them prepare them and make sure that they deal with them outside. They must not just throw them out, but they must have a way of dealing them outside this amendment bill that we are dealing with. Other than that, we accept the detailed presentation that they've made, and we really thank them for what they've done, and we accept this presentation. Thank you very much, Honorable Chairperson.
Thank you, Member Nkosi, Member Baha.
Thank you, Chairperson. And I also want to echo the same, that we accept the presentations being made or done in this particular meeting. But one thing, Chairperson, that I want to check, how much time do we have in terms of the court, the court decision, in terms of by when should this bill be done with? So in a sense, I'm just trying to check how much time do we have between now and the point when the bill be settled.
Thank you, Member Baha. I think maybe I must allow Nati to answer that question, but I think we're still in our scope. Nati, can you just answer that question of Member Baha?
Thank you, Honorable Chairperson. Chair, the period ends at the end of November. So this is our last month within which to ensure that we comply with the court imposed deadline. Thank you, Chair.
Thank you, Nati. I think, Member Baha, you covered now. If there is no any other member, let me then also take the opportunity. Let me first start by thanking our support staff of the Select Committee, because I know you have put in so much for making sure that everything is in order. We meet our timelines and the provinces are informed of the process and all the work that you have put in. You were working under pressure, but thank you very much, Marcial, Kululi, Tabile. Thank you very much for your hard work. Let me take the opportunity to thank the Department of Social Development National, as well as provincial departments, for doing such successful public participation within this process. I did follow some of the provinces, and I could see that the hard work and the effort that was put in to make sure that the public really takes part in this process. Then to the legal team from DSD, Parliament, and the State Attorney's Office. You know, without your legal advice, we will really have a very, very hard battle to meet our deadlines and to be in line with what this committee must do. So thank you very much also for your support. And then finally to the members of the legislatures and the chairpersons of the portfolio committees in the legislatures. Thank you very much for your effort that you have put in, and also for our members, permanent members that went to the legislatures and taking part in this process. I think this has also been a very good process for national and provincial government to really work together as well as local government. I am really looking forward to our next meeting where we can do our final mandates so that this work can really now come into practice. Our children in South Africa really needs us, communities needs us to make sure that this bill becomes law so that circumstances can really change into the lives of our children. Thank you very much. Without any further ado, members, all our guests in the meeting, thank you for attending this meeting. I declare this meeting as adjourned. Thank you very much.
Thank you very much, Honorable Chair.
Thank you, Chair.
Thank you, Chairperson.
Thank you.
Thank you, Chair.
Thank you, Chair and members. Thank you.
Thank you, Chairperson.
Thank you, Chairperson and members and colleagues.
Good night, everybody.